Welcome to everybody who's just got here, and the mess up was entirely my fault. I'm going to hand over to Steph now.
Okay, so yeah, thank you everybody for joining us tonight. I'm really glad that we got to work this out like earlier in the year when we were addressing what we're going to do in the context of COVID. We thought, well, we'll have to cancel the research class, but then we remembered we had Nolan, so we're like, we pretty much own the internet, so it's wonderful to be able to take this face-to-face class online. Also really excited to introduce two people from Maddocks. We've got our guest speaker, Stepanovic, who is the president of the Victorian chapter of the Australian Librarians Association, where, and she's also from Maddocks as a law librarian, and she oversees legal research and training there. So welcome, Anna.
Thank you.
And we wouldn't have Anna tonight or this workshop as it is without Maddocks. So we're really lucky to have Jess Parker here repping them tonight. Maddocks is one of LSS sponsors, and they're essentially helping us to support you guys, addressing all your concerns around legal research, but just generally how to step into the law. I also just want to take a moment to point out that Maddocks does run seasonal clerkships, and I'd really like to encourage you to jump on their LinkedIn page or through their website. They've got a page on clerkships. I've shared that in the Facebook event page for tonight. So you can click through that and you can see it's got a lot of really great information on the steps that you need to go through to enter a clerkship program. It's also got information on previous graduate experiences. So it's just a really great resource. So that's me. Welcome everybody. I'll hand it back to Kath.
Hey, thank you. Thank you so much. I love doing this. Just before we start, I just want to ground us all a bit. I would like to just pay respects to the traditional owners of the many lands on which we stand and we come together on tonight, to pay respects to their elders past, present and emerging, and particularly to those Aboriginal people who join us today, and to mark this as being, you know, one of the great things about a small law school where so many people can come together in this way. And I know we've got a lot of people around here today, and I stuffed up with the link. Somehow I had two meetings running at the same time, so there'll be people coming in, but it'll all be recorded. And I also want to acknowledge the hard work that Steph, as the Education Officer for the LSS, does. And for those of you who aren't involved in the LSS, you should do so. She told me today I was very sad that she's stepping back from that position, but it's so great with this new first years coming in and getting involved. Can we do a little bit of housekeeping? I've got no idea where the fire exits are. You better pay attention to that yourselves. It would be great if I'm going to ask Anna and myself to keep our microphones on and we will have a conversation. And if you wish to butt in, you know me, a lot of you know me anyway, I get excited, we're having a conversation and I won't notice, so just unmute with your actual question as we go. I'm pretty sure Anastasia is pretty comfortable with that as well. I'm really hoping that she and I disagree on a lot of things because that makes it actually all the more interesting. But if you are shy or otherwise, or if you think your question might fit in somewhere else, if you can whack it into the chat, that is fine too. So we got a whole lot of questions in advance. I'm just actually going to share my screen with you because this is kind of the agenda, because this is just really a conversation as much as anything that we're going to deal with today. So Steph and I had a look today at the questions. I rearranged her thinking a little bit. I created this mind map based on the questions, but the questions basically came into this Mentimeter piece. There are a few overlapping, few kind of themes, so we'll do our best to try and address as many of them as we can. Hopefully I'll put them in a pretty sensible way. And the other reason for doing this is to just get the links into the RMIT materials. I'll publish this when we're finished as well, so you've got something that you can add to and that we can grow. That's one of the nice things about not actually having to get off my butt and leave my house and come in to do this in the city, is that time I can spend actually putting some resources together, which is pretty cool. So everybody happy with that kind of agenda? Awesome. I assume you can see my screen because I can see you. It's so much better than collaborate. I've got to stop sooking, don't I? So I want to start where everybody wants to start, Anna. So actually, firstly, let's just talk a little bit about you and why we should listen to you. In other words, why you should listen to her and not me, because she knows what she's talking about. So you've been at Maddocks for about 10 years, you said? Is that right?
No, it's coming on close to 8, nearly 10. I'll be there eventually.
Oh, it's rounding up.
That's right. Yeah,
So, and so I know a number of the people who have worked with me in classes have heard me say, if you want to be a good lawyer, there are a couple of things that you need to do. And strategically, one of them is make friends with the librarian as soon as you possibly can. Like, basically, the two most important people in any law firm are anybody who's going to help you in the library and the managing partner's PA. They are the two people that you do not want to piss off. If you go away with nothing else, that's pretty much the most important thing. So why would I say that, given that you guys, like I came out of law school just the same way you guys came out of law school. You spend however many years learning how to do research. Why does it matter? Like, have you got any stories for us about what it is that, because it's a very specialised role, a lawyer, a librarian, not a lawyer, but a librarian dealing with legal issues. So what kind of challenges do you see in law libraries every day? Because that's where you are.
I apologise if my internet is lagging in some way, but I will try and keep up. Important to always make sure you are quite close with the librarians. I'd say to all seasonals and graduates when they come in, we are your safety net. At the end of the day, you will ask questions of the buddies and the lawyers who give you the research to do. We're here for you constantly. We have the answer, rather than you spending over 3 hours looking at one question, and then you come to us or any librarian and you say, I'm looking for this, and then within 5 minutes we've probably got the answer for you. So always best to heed our advice. Ask us before you start, and we will not just give you the information, we show you how to do it. So then that way you feel confident going ahead in building your own skills. So this isn't just something that we hold to ourselves and close to our own heart. It is something we impart on you. So then you feel confident to go ahead and tackle those questions. If we weren't around, you'd be sitting there most likely Googling and trying to go from A to Z in a very roundabout way, whereas we can show you the tricks of all A to Z.
One of the challenges for law students at RMIT in particular, and it depends on in larger law schools, there are specialist law librarians, where we have librarians who have the technical specialist skills around law, but they're also across the whole range of business and other skills. And our library staff at the moment anyway, we don't have anybody who's got deep practitioner experience. So it's not that, but that's not that unusual for graduates in summer class to come out not really having had access to deep library skills from the very beginning. And there are two things, as I said, two things that are coming out of what you're saying. One is it's reproducing another thing that I know I say all the time, I love it when I'm right. The difference between a good lawyer and a bad one is not knowing the answer, it's actually knowing what questions to ask. So effectively, Anna's saying, actually, we can help you find the answers, but it's your job as a specialist to work out what the questions you need to ask are. And secondly, it's the growth at the very beginning of being able to research is one of the things that you need to learn in order to end up being the managing partner.
Most
The
definitely.
more
it's the hard
time
work.
that you...
That's the hard groundwork that you've got to do initially.
So when people start with a question, again, look, I'm really happy for people to throw something in here. So you guys, so one of the first questions I get often is, well, where do I start? Where do I start? And so I just want to throw it open to people in the room here, throw it in the chat or just call out, where's the first place you go when you have a legal issue that you need to research? Where do you start? I'll just go to the students first. There's always an awkward pause.
At this stage, often
at this
still
point,
Googling like the meaning of words or looking them up in the dictionary still.
Absolutely. I think we need to get the dirty little Google secret out at the very beginning. I personally have no problem with people starting with Google. What I have a big problem with is people finishing with Google. And again, there are skills around using Google as well. And do you agree, disagree? Do you have anything to throw in there?
I disagree. I think you shouldn't start with Google. I think Google should be in the middle of your research grouping. Definitely not at the end, not as the finish line, but Google should not be the first point of call. I know it's easy, I know it's simple, but the information that's provided to you at school, at uni, is all there to guide you, really. And if you're putting in the correct terms and you're popping it in the correct format, you're going to hit the nail on the head straight away with accurate advice, accurate information to guide you. Whereas we've had many an issue with some lawyers and graduates who have done research initially with Google and have taken it straight to the client, and it has not ended up very good advice at all. So it's been quite old or dated, and the information's not shown to you quickly within Google. So it's quite it's very important to start with what you have available to you within your library space, then put that in the mix with Google and do a bit of back and forth that way.
And I think it's probably worth just spending a minute or two just thinking about the risk with using Google. So again, one of the things I often see cited in assignments is materials from law firms. And often they're really good. They can be old, they can be, they can be fine, but they are really, when you think about what the purpose, why do you think a law firm puts a case note or some information about the way the law works on the internet for all and sundry to see? Clearly they're not giving their shot. They're actually just teasing people into coming and getting some advice. They're demonstrating their expertise without giving you everything. So the chance of you finding everything that you need in a law firm's piece of advertising, actually, that's what it is, it's advertising, is quite limited. Another thing, and I wonder if you've seen this, Anna, with lawyers, I often see precedents that are coming straight from the US. That dollar sign that looks just like ours, and use of words like consideration and negligence, they use the same language, but it can be very, very different. Have you come across any kind of ridiculous thing, well, not ridiculous, but lessons learned from using Google that you might want to share?
A piece of legislation. A piece of legislation was used to let a client know that this was what it was at a point in time, and this section actually had been repealed much earlier than what was presented to the client. So all the information within that research memo had to be thrown out, and we were in big strife. So that took another couple of more 6 months in court to try and rectify and fix. So, and that was just by going off what Google said. It was the first result that someone had clicked on and went, oh, that's exactly the information I need. And unfortunately, that section was no longer in force.
Well, actually, when we were chatting and preparing for this the other day, Anastasia, you said something that I thought was really insightful. You said the first thing you find is never the right thing. Like, it's not, when you're actually trying to research, the chances of you finding the right thing first go is just infinitesimally small. And so going back to that, if we're not going to use Google to start off with, and to be fair, I don't particularly have a problem with it, but I can think of better ways to start as well. Probably have a few years of experience that will help me there. What other places do you suggest that people go once they've worked out what area of law they're researching, or they've got a broad question that they're looking at? What kind of resources would you start with? Straight to the cases, go to a textbook? What do you think?
Straight to the textbook. I wouldn't consider cases until I've got all my ground understanding first. So as soon as I know what question I have, know the law, I would then find out the purpose behind it all. Get that good grasp of the paragraph or the chapter that would then contain cases and journal articles to then follow off with. That is your best starting point, and I wouldn't start with just one database. You have to search through all relevant databases that would cover that subject law, and they will come up in a search over your library catalogue to let you know and identify where they are. I would make sure I would be thoroughly searching everything.
And that's a question we're going to come back to over the course of our discussion, because that comes up a lot. Like, do I have to check them all? Do I know, how do I know which is the right one? So just getting into my list, so I want to keep adding to this as we get your tips and tricks as we go. Textbook, I actually often start with the index to the textbook. And I find myself that also the lists of cases can be really handy in just trying to get a sense of, well, on the basis that a textbook, and in the areas, I work in commercial areas, everybody's writing textbooks all the time, right? So often you've got a number of them to choose for, and when you're seeing patterns, and all of us, somebody's writing style will resonate with one person better than another. But in Australia, we are really lucky, but particularly across the Priestley 11 type subjects, that there are a range of really well-written, well-resourced materials. And I know a piece of advice, I've been doing a lot of consults with students this week, and particularly about writing as opposed to research, but one of the tips that I'm regularly given is look at the way your textbook's written. Like, it's written in a clear way. It's balancing every statement of the law is supported either in a footnote or in an in-text reference with a case or a journal article or relevant legislation. And the more important the case is, the more likely it is to be an in-text reference with a quote in it. And all of that helps seed our understanding of, well, what are the nuances in this issue that we're dealing with?
Definitely. If I might add to that dot point that you have to search the index of your textbook, it's not just a textbook you are searching commentary, which is also titled a loose leaf service. So please don't get these two confused. A loose leaf service or commentary service is actually updated constantly on a monthly basis. There's authors to go in there, and as soon as a new piece of legislation comes in, something's affected and changed, new wording goes in, new cases go in. Textbooks, on the other hand, they are editions. So sometimes they'll be done yearly or every 4 years, every 6 years. You'll notice a pattern when you see the edition with the years in the textbook within there. So please make sure that they both go hand in hand. Your textbook, say for example, I don't know, Del Pont on costs, for example. He brings out a book every so often, every couple of years.
When I said they're all well written, anything by Del Pont just makes me
anything by Del Pont or Ford or Austin. Who else have you got? You got Croft.
Bob Austin was my company law teacher, and I love him. But no, Del Pont, like he so well researched, so deep, that the law will be right and every nuance of the issue will be there.
That's
but
so
you
true.
will read 15 pages and think, why did I pick this profession? Like, hey, actually, I was interested in this question before he started.
I know, you think, I was really interested in this topic and he's just ruined it. So that happens, it does. But it is very important to know your author, especially when you do go and do a seasonal clerkship or a graduateship at any law firm. The first thing a lawyer will say to you is, oh, have you read Williams? And you'll go, who is Williams? Williams Civil Procedure. That's why the library catalogues are there. Chuck in the author's name, the surname. Predominantly when someone's referencing a name, it's the author's surname. So keep that in mind.
Yeah.
Always
Well,
trips
and
up
also,
everyone.
lawyers, rather unhelpfully, in my experience anyway, are not particularly in love with AGLC4. We're not using it every day. It's like it's not at the tip of our fingers. But when you think about what referencing is for, clearly academic integrity, you need that, right? It's really important for you in particular. It's also adds credibility to the work you do, but also referencing is about letting the person that you are doing the research for know where you looked at. So one of the things I know, and I don't know whether this is required across other subjects, but though pretty much everybody's either doing contract law with me, has done it. Actually, you won't be in the future if you haven't got me, but anyway. But I will always ask you, the same as I did with any graduate that's ever worked for me, I want the whole list of what you looked at. And practitioners will always want the whole list, because what we're going to do is we're going to actually ask you, what's the answer? Yes, no. We want to know where you stand. And then we want to know what you looked at. Because as the older we get, the more experience we have, we think we've got a gut feel as to what's logical and which way it will go. But also, we know what we would have looked at if we were doing the research ourselves. And if you've looked the same places as us and come up with a particular answer, actually you're going to look good with the person you're reporting to. If you've gone and looked somewhere completely different, particularly if it's just Google or, like the guide to estoppel for dummies, like Estoppel for Dummies or whatever the equivalent is, it might not go the same way. So, yeah, absolutely.
That's why it's important to know your legal researcher on hand so they can be your backup. I've gone everywhere, and we'll go, okay, well, where's everywhere? What's your search string? So that's our questions to you.
And one of the things actually in my experience why I've always actually loved being able to talk to the law librarian in the different firms I've worked for or where I consult is also because they're not practitioners, but they understand what the resources are. Often it's a really safe and good place to work through your logic, to actually pare it down into plain English and not, throw around the terminology which is just jargon at the end of the day. So you pare out the jargon and say, okay, I've looked in these places, I think this is the key issue, and for these reasons I've looked at that and I've come up with that. Does that make sense to you? And you've got an intelligent non-practitioner to feed back off, if they have the time, of course, which
definitely. And more often than not, once you visit that legal researcher of yours and you pair it back with all that legal jargon and you just tell them in layman's terms, the answer comes to you. So when you've taken that time away to actually just talk about it and go, oh, well, I can't really explain it in legal terms, I'll explain it in layman's terms. And for you, it's a different way of thinking. So being able to step away from that and pull yourself away from it, you're thinking of different wording, which is so important. The wording, all words that you use, all search terms you use, is either coming from the lawyer or from us, and they're going to be two different. It's like synonyms, pretty much.
So the next actually leads really neatly into identifying search terms, which is, what are good terms to to use, and then a kind of side question that I think sort of goes with that is any tips and tricks about the secret best Boolean search tips to use? Is there something in particular?
With Losley, it's the word
one other thing I wanted to talk about before we got to the search terms. Of course, I'm disorganised as usual because somebody mentioned it early on, things like Halsbury's and dictionaries, words and phrases judicially considered, they can actually be sensational places to start as well. I see she's got it in reach.
I took them home with me. I've got a whole collection behind me. These are your best friends. As soon as you are asked for a judicially considered term or phrase, books, because the online resources, and I have experience hand in hand with this, the people will come up to us and say, I found 2 cases on Lexis under the words and phrases search, and I'll say, well, I found one, and it actually defines it and shows you the definition.
Yeah.
leading.
So I've got actually one of those, pretty much every article clerk I've ever had, that has been my admission gift, is a big fat Butterworth. But isn't it interesting, you approach that from the point of view of people being asked to actually go straight to, I want to know whether this word or phrase has been judicially considered. The reason that happens is more senior practitioners realise, actually, this word has been used in this contract, in this dispute, in this sign, in this advertisement or whatever it is. I need to know what a court will decide that it means. And so they go straight, they've turned their issue into, okay, I need to know whether there is another issue, another consideration I have to have just because of the way this term has been used in the past. And so they've already kind of started to narrow in the research there. So you at law school, that is actually something that's often, nobody's going to tell you, go and work out whether this word or phrase has been judicially considered, but it is something that is pretty quick and easy to do. Probably less easy, particularly at the moment, to get a physical dictionary. Although actually, as your intro text, aren't you all supposed to buy a dictionary anyway? I think it's just a little one. Now,
it's a recommended text.
Actually,
but it's not.
You do realise every text
there's no.
We're not allowed to actually prescribe text, but a dictionary is it's pretty handy.
Definitely, and it saves you searching for more than 30 minutes. If you've got the hard copy dictionary, or even the Encyclopedia Legal Dictionary from LSS, get the definition straight away from there. Don't waste time. Get your definition.
Halsbury's is good in that regard as well. So even if it's not actually working as a dictionary, there's you can look for the phrase in the encyclopedia, or the Laws of Australia or Halsbury's Laws of Australia. Both of those will give you something. They're both good starting points. I want to recommend things we've got.
No, definitely. I actually have a question. Who prefers what though, Halsbury's or Laws of Australia?
Anybody here?
We have had some comments in the chat from Daisy. Daisy, if you want to come on the mic, we'd love to hear you.
And that's a good question. Daisy's actually asking what a loose leaf surface is, and of course at RMIT we don't have loose leaf. We have the internet, so we only have those.
Everything's online. So loose leaf service is a commentary service. It is predominantly. This is your act, so say the Corporations Act. Ford and Austin have annotated that, and they are describing each section, subsection, giving really.
I'm just going to grab one to show you what they look like.
Also, they're like
loose leaf service is old man's
copies.
term. Yeah. Loose leaf service is pretty much a hard copy, and we call it now commentary because it's now online.
Yeah, and so you can access that online through LSS or?
Yes, yep. Any database it sits on, so we can see what Cathryn has here. It says CCH on the folder, so you know which database you're going to.
Oh, perfect.
It's old.
You know it's old. But this is an old listing rules one, so it's a good 10 years out of date. But also this is when I was a young lass, one of the things that paralegals and junior lawyers had to do is when the publications came in, so the mail would come in at least once a week, you would have these pages and you would literally go through, take out the old page and put them in. Or with legislation, sometimes you'd have to cut them up and actually glue the sections over. It was like craft for lawyers. And at the time...
It's still done to this day.
You still do it?
It's still done.
It's a terrible, terrible job. I just hate it. But actually, I learned a lot of things doing it that I didn't expect to learn. It kind of, the number of times that I knew that actually there'd been a whole lot of changes in some particular bit of legislation because I'd had to sit there and do that task, which I wouldn't necessarily have known, or I would have had to have paid attention in a different way. So, yeah. I guess we do pay attention in different ways now. I don't know about you ladies, but I would probably get in the order of 15, 20 emails a day, which are just kind of different update services that are telling me and it kind of goes into the thinking music part of your brain, you know, like I'll get alerts from the ACCC, for example, on particular issues that they're looking at the moment, because that's an area of law I'm interested in. Or you get alerts in relation to, well, you know, I subscribe to them through Ostley and through Jade. So for example, when I'm teaching contract law, I've got alerts set up on all of the cases that we cover. And once a week, I will get an alert email to tell me. I ignore it mostly. And then when it comes to teaching that week, I'll just do a quick Google. Well, not Google, but, you know, search across my emails to see if anything's come up, to see if it's been cited. But anyway, we digress. So the reason I went back to dictionaries and things like that is because I actually think dictionaries can be a really good way of thinking about putting together search queries. Because if we know a term has been used in a particular way already, we've got that starting point, then we can then use that term with something else. So find, you know, the merging of the cases. So that's something that I do very often. What I've tried to do here, which I'll give you, is Ostley, which a lot of people love. I find Ostley really difficult to use myself. I mean, again, not a litigator, so I tend to approach it in a different way, perhaps. But this is quite handy to have this cheat sheet. And Jade also has something kind of a little bit similar, although Jade I find I can use a bit like Google. It's a much less flighty search engine for my money anyway.
How do you find these, Kath? Sorry?
I'll share these with you, but so this is actually on the Ostley website, this one.
The Ostley one, I would suggest only use the word near. The rest of them, I wouldn't worry about. Make sure you do have the phrase, yes, with your quotation marks. But other than that, don't worry about not, don't worry about and, or it's pretty much a Google search, but to get the word, say, contract and permit, rather than using contract and permit, use contract near permit. Near is 50 words to and fro of the word you're looking at.
Yeah. Oh, that's good advice, because I often find it really hard to find things in Ostley, and partly because it just seems to have so many different things going on all at the same time.
Yeah.
And again, you know, this is a question we get a lot when we do these things is, how do you know which database to use? How do you pick them? What are they best for? How do you know which one? I don't think there's an answer to that personally. I'd be really interested to know what you think, Anna.
I normally describe, and I guess it just depends on how you feel, but if you think of the legal scales, the STEM is Lexis because he has a bit of everything. Westlaw is the journal man, CCH is the commentary man, and they all balance each other out. So they all have a bit of everything, but Lexis is your middleman.
I love that. I'm doing a challenge where I'm trying to draw a picture every day for the next 30 days. That is so the picture I'm drawing tonight.
That's the next picture. Share it with me.
I will do. I will. So, and again, because again, it's kind of, we started this conversation before, and I know in this area we're in heated agreement, really, that there is this starting with secondary sources, but then honing in to getting the right primary source. And, you know, the risk of mixing my metaphors, the secret source for any kind of academic writing is you want your work to have credibility. You need to be able to address the arguments on both sides, but land somewhere. And so if you can do that with the backing of suitable secondary sources and the primary source yourself, your writing has so much more credibility. And so much more impact. And I really think of it as like every time you make a statement about what the law is, you want to have a case. And like, you know, the joke in my course is, well, like if you can't think of anything, just say Carl Hill and carbolic smoke ball, you'll probably be right. But the reality is I am going to look at that and think, yeah, well, really? But I tell you what, that beats quoting Tess Hardy and I in the course notes. They have like pretty much no credibility. You know, Jeannie Patterson and others at your textbook, they're up here again. But then when you've got specialist QCs or judges who are writing about particular cases where they were actually involved in them, they beat that again. And then the actual words that the judge said beats it again. So it's like this kind of game of poker where you're going to try and trump it. And then again, and by the way, if anybody's getting feedback from me, when I actually point to a reference and say, could you have given me a pinpoint here? Could you have actually directed me to the actual bit of the case? Firstly, that's because I'm a practitioner, and like every other practitioner, I am lazy and I only want to do stuff that the client is going to pay for, which means I don't want to read the whole case if I only really need to read one paragraph. So getting me to the paragraph is important. But secondly, it demonstrates that you are, from an academic point of view, that you're not just throwing a citation at it and hoping it sticks. You are actually focusing on the bit that counts, which is why I have this love affair with Jade, by the way. I know all you guys, people who've worked with me before, they know Jade is my go-to research choice. And it's got that face, which means she doesn't like it, which I'm really excited about because I love to know why. But that's, which is great because I think it's just, it works for me. But look at me, I'm messy, I'm noisy, I don't always make sense the first time I say something. Jade and I were meant to be together. What do you know?
Sounds like the perfect love affair.
So what about you? For cases and things like that, where would you go first, Anna?
I'm a Westlaw girl.
Ah.
Through and through.
Very fancy.
Oh, yeah, I know.
So tell me why. What do you like about it?
I know that I can just chuck in my citation straight away in the front screen. I've got this tab that comes up that says citing references that takes me to further commentary on different topics that had arisen from the commentary cases journal article itself. I've got beautiful litigation history. Everything is there nicely for me.
Yeah.
Jade,
yeah,
can't argue with Jade, but it does miss a lot of cases. So for me, when I am doing my legal research for a lawyer, it is the last place I go to. I'll be honest.
It's funny. I see. It's where I go first. Well, I must admit, I don't if it's a New South Wales case, because bizarrely, even though they're all it's all made by barristers in New South Wales, the New South Wales stuff is shit.
Yeah, it's not right.
But I like the ability to, with the citator, to go directly to the paragraph, so I can find. It's sort of working on the logic that the paragraphs that are cited most often are probably the most important. It's kind of, and that really is a practitioner's rule of thumb that resonates with me. I know a lot of people hate it, but I love the bouncing balls and the correlation stuff.
They're great when you get to that.
Yeah, I know. Well, and one of the great things is and I'm happy to show you guys that if you want to have a look at it, but Jade makes its full professional service available for students. So all you have to do is email them and say, I'm a law student, I would like to use your professional service, and they will give it to you for free, which I think is spectacularly generous of them. And clearly it's part of their marketing. They want you to go and work for Maddocks and then say, yeah, oh, you've only got the free version of Jade. We want you to invest the big bucks in the spectacular version because we know how to use that. And that may or may not work for them. I don't really care whether it does or not, as long as they stay open and I keep getting to use it because I quite like it. But I like that, again, because I'm a messy person, I like drawing those similarities and being able to find the things that I couldn't find. For those of you who haven't seen Jade, what I just said will make no sense. So if we get time, I will open that up and I will show you as we go, because I want us to have a look at some of the databases as we go. One of the things that comes up a lot and we have access to at RMIT is first point and case-based, which are kind of similar but different, do similar sorts of things. Often people will sort of go there and then go to the main case to have a look at the case. Sometimes you'll be reading the case and you will see that it refers to other cases, and you might then go back to case-based or first point to sort of see how it connects things. I think if you've got the full Westlaw package and you can go to commentary as well, you wouldn't even notice when you're going in and out. I can't remember which one of them is Westlaw. Hopeless. They're just different publishers. Sorry?
The blue icon.
The blue icon. Yeah.
Blue. You got red, blue, and green.
So we had a question about that. So actually, let's have a look at them. What I want to do is actually, so from an RMIT point of view, the RMIT sources, I've got them linked here. If you go into your library subject guide, this is, now by the way, any of these databases, you can just go to them directly through the library search engine. You can look for Halsbury's Laws of Australia or Just Laws of Australia, or I know second assignment time, so my guys will be looking at the Encyclopedia of Forms and Precedents. And one of the reasons I like actually getting students to have a look at that is it's got some actual work product that looks a bit like what lawyers might produce. It's got commentary and it's got links to cases. It's got the stuff that we use in the profession. It doesn't necessarily have the best precedents you're ever going to find, but it's got something there for you to work with. But going through the law subject guides is a good way to do it. So again, if you just go to the library website and you work down, you see business and law, you can click on that and you come down to these subject guides, and I've just gone straight into the law one. And this, in some ways, gives you some really good insights to how to do it. It's funny, I've always laughed about this, and I'm enjoying having you here, Anna, because I can see you, like, we've approached this in the same way. I would do what the library tell you to do in exactly the opposite order. Like, they basically end with find stuff in books and move down to go to the case. So they kind of assume you know what the case is before you've even started, and often you don't. And so you sometimes have to just play around a little bit to see if you can find cases that either have similar facts or have, particularly once you've done that identification of what the key words are, that you're going to work into there. Sorry, I should be asking questions rather than doing the sermon thing. I'm too used to this standing in front of my camera and just ignoring everybody. So let's just have a quick look at first point. Again, a lot of this stuff in our library, you're going to have to go through a couple of cycles with logging into things. I actually went and made sure I logged in earlier so that we had a way of doing that. But just a little aside, get yourself a password keeper of some sort. LastPass is the one I use. There are plenty of them around, but you will find you're logging in and out of different services because all these services are published by different people. It's all about intellectual property rights, and so you're just sort of moving from one service to the other, and that can just save you time, just having something that automatically populates that stuff. One of the questions was, I don't know why I look for cases and they don't exist. And the example that they gave was Musumeci and Winnedell. And so I thought, actually, that's a good one. Let's actually have a play with that using a few different tools and have a look at actually what happens. So if we're here in the blue one, and we put it in, here's one I tested earlier. Nothing appears. Oh,
glad you're doing it this way.
That is actually
I'm so glad you're doing it this way.
Yeah, well, So, one of the things that can help, I don't think it will help me particularly here, is, I don't know, it didn't find me anything. And that, well, maybe it did last time, probably because
Maybe put it up in the next field above.
Oh, sorry. Let's see if one gets it. We get lots of different things though here. This is wasting my time. I know that there's a particular case that I want to do. Now what I would do, there are lots of different ways of doing this. Probably quickest way is go to your textbook and get the proper citation. That would be the easiest way to do this. One of the things I do, I will often use Jade for that. I'm just going to pop into Jade here because one of the things, even when it doesn't have the case, that I think Jade does quite well. Come on, and of course it's making a liar of me. Musume echi is normally, is this because it's sitting in some weird browser? Normally it would just bring it up. I'm just going to bring up, I'm just going to pull in a different browser here, because sitting inside another piece application is probably not helpful. That is not a helpful browser window. It doesn't actually have a search engine in it. Here we go. Do you think I have enough tabs open, guys? There we go.
Sit next to me.
Okay, it's even logged me in. Musume. So, oh, spell it correctly. So what I like, took me a long way to show you something that's supposed to be quick, because why I like it is that it's quick, is it will bring up as basically like a Google search screen, the most often searched with that kind of term. So I've got the whole case there. I just need to click on it. Now, actually, it says New South Wales decision. Surprise, surprise. It's not in Jade. But the first thing it gives me is a link to the New South Wales Law Report. So I'm getting an authorised edition anyway if it's got access to it. Now, I would have to pay for that, so that's not going to help me. But it's also giving me the full citation. So again, that's my quick and dirty way to go straight back to where I started before. Don't tell me that's, I bet that's disappeared. Ah, damn it, because I was in first point. No, I went to case-based, didn't I? I can't remember. And I've got my citation to whack in. It was first, oh, see. That's what I mean. You just see your login window 7 million times. And so then I can just throw in the citation and I will go directly to the case that I want. So I can click on it. The other thing that is quite good, well, I quite like about these Westlaw processes is everything's flagged. So yellow means, yeah, it's a little bit dodgy. Hasn't been overturned yet, but actually jury might be out on whether or not this is the best piece of law. I can get a PDF of the full case pretty much straight away. And then I've got these different tabs. So firstly, I start with my
references one is the best.
Yeah.
Just saying. So everyone knows.
Everybody has to have their own thing. Doesn't have bouncing balls, and I think, you know, that's what I really like. I've got my digest notes here. So here I've got immediately a summary of what the key points were. I've got other terms that I can search for. I can see what legislation, and then I've got this amazing citation report. Now, what is particularly nice about these, now these are, so editors do this, so these are people with legal skills, with understanding about how these things work. They are giving us, with these little flags, okay, it was applied in this case, but that case itself was overturned. So that's one of the reasons why we would have that yellow flag, that there must be some development happening in the law. So that helps us establish, rather than just throw this great case at the problem, it gives us some ability to consider what's actually happening in relation to, what's that case about? That case is about when you vary a contract later. What's it called? Practical benefit rule. Thank you. I've only taught the subject for 10 years. You would think I would remember, but no. So, yeah, look, I guess this leads to the question, there are lots of databases, they all do different things. I've never had a good answer for the question of why would you pick one as opposed to another. Often from my point of view, it's been, this is the one I'm used to using, I know how to use it, I know, like, I don't have to figure out what box to type things in, I can just type there. But each of them have their own strengths and weaknesses. You want to talk to that? I mean, clearly You like your Westlaw, but
oh, but it's not the only place I go to. You have to go to all platforms that have a type of case search available to them. So in case in point, a lot of these databases, they do a legislative note up, and I had a partner ask me, I need a note up of a Local Government Act section, and I showed him because he wanted to know at the same time, and he just went, well, we just go to Austlii. So we went there, and there was one case. He said, no, there's an authorised version. Where is it? And I said, well, Austlii would normally bring up everything, and that's normally a rule of thumb at any law firm. So we went to LSS, Jade, CCH, and Westlaw. So that's like the main Fab 5. Each of them had a different case, completely different to all of them.
Yeah. All
of them had something different. And if we hadn't searched that, he wouldn't have found extra information to go on to send to the client and say, you know what, actually, there wasn't just one case, and it wasn't just the one I was thinking of. It's actually been spoken about again further.
Yeah. So
and this will happen with your case law too.
Yeah, absolutely. And look, it absolutely does all the time.
You don't want to be caught out. That's something you really don't want to be caught out with.
So I'm going to put a note again, should I use them all? Yes.
Yeah. Even if you do your search string or you've searched in it and it brings up nothing, at least you can note that down and go, you know what, Westlaw's actually got nothing for me, but I found everything in LSS. Yeah. You've done that. It's a tick off the box.
Going back to what we were talking about earlier, most practitioners will be looking for you when you're doing research as a junior lawyer for you to tell them everywhere you looked. Even if you didn't find anything useful, I want to know where you looked and what you were looking for, because that is actually interesting to me and actually making an assessment of whether you've got it right. Because, again, you guys have all heard me say this, you get it 80% right at law school, you get a HD and your mum tells all her friends how brilliant you are. You get it 20% wrong in a law firm, and chances are that people are trying to cover their asses really quickly and this firm could get sued. So, you know, kind of there's two sides of the one very, very evil coin. We've got another question in here. So Maria asked whether that was a professional Jade version. The one I had open was. We can talk about that. Basically, Austlii is the one that's completely free and everybody gets the same thing all the time. All of the other databases that we have, they're all published by different people. We don't have, RMIT doesn't have the most comprehensive list of databases, but it's a pretty good list, and many firms wouldn't have as many resources as you have available to you. When you go into the firms, particularly this time of year, this is when licenses are being renewed and budgets are being fixed for the next financial year, and there's lots of argy-bargy and negotiation in the firms about, okay, where are we going to spend our really valuable knowledge dollar at this time? So it's, again, I want to acknowledge that because we've actually asked Anna to be with us in what is actually a particularly busy time of year normally. I didn't even realise that until just then, and I just thought about it. I know that happens to be true.
Not at all. This is my passion. I love it.
It's easy to love. Sarah's asked a question. Can we comment on the treatment categories applied by, distinguished, considered, or particularly in Westlaw, the blue one? So we were looking at, and so this is this labelling here.
Yes, and that's important. It comes up in case-based and first point. So this is where a lawyer will ask you, I'm looking at this case, has it been applied by any other cases since? And this is your answer. Has it been distinguished? They're the two main ones that you'll find are asked, distinguished or applied by. So look out for those terminology. And case-based and first point are actually the only two databases that will help answer those questions.
Yeah, well,
Jade
you can always find it out by reading the case, clearly.
You can.
Well, but that is the long way round. So when you have these services where effectively they've had editors and that is their job to go through and look at, okay, what cases are actually cited here? Were they cited with approval, or was it distinguished in some way? Was it even overturned? And then they're creating these little signals here. So Jade doesn't do that. For example, they say, because it's run by barristers and barristers know more than anybody else. This is why they're not allowed to work in partnership, because they can't get along with anybody, right? So they just say, no, you should read the case and work it out. But then they've got this clever little tool that means you can go to the paragraph very quickly and read it. So you don't actually have to read the whole thing to work it out. But they won't actually signal. I don't know whether they can't or they've just decided it's part of their business model. Where these guys, now look, and to be frank, particularly in a serious piece of litigation or when you are really relying on it, just relying on the signal in Westlaw is not enough. The fact, for example, so this case is now interesting to me because it, well, it upheld, it cited in some way Musumeci, but subsequently the decision was overturned. So the decision in this cause. So because I'm looking at this in the context of I'm interested in the Musumeci decision, I might find that I want to go and read that quickly and see what did it say about Musumeci, and was that a point that was considered in the subsequent appeal where it was overturned? I've got to work out if it's my point that is of interest. And that's a kind of flag. Anything that's just, yeah, upheld it, I don't care about it terribly much. It's just that's business as usual. From when I'm doing research, I'm looking for the red flags. That's why they make them red. Sorry, my messy little map. I'm just paying attention. We've been going for an hour, so I just want to make sure that we move along. How long have we got, Steph? I've assumed we've had 90 minutes. 90 minutes?
Yeah, I was just going to say, if we want to throw it to the floor for questions, we'd think about wrapping up in the next 10, 15 minutes.
Sure. We can do that. Because I think these next ones are pretty straightforward questions in a way. So somebody comes to you with a case, Anna. They say, how do I know that this is still good law? Now, we've already talked about some of that with the red flags, but what other techniques would you have for working out, is this a good case? Is this my smoking gun case?
I would definitely be checking for those flags to make sure that there's no red or yellow flags on it. Definitely to see if it's been in appeal. So I do like the headings in Jade. So I don't dismiss Jade altogether. Yes, or as soon as you find the case in Jade, at the top there's like a little yellow disclaimer that says this case has been overturned, or this case is currently under appeal. Yeah. So they're really good headings to see.
Actually, the other thing I love there, which is a real tip for you guys doing assignments, is you can actually copy the full reference and it will be copied, formatted for AGLC4. Just saying. That is a really handy, tiny little thing. So if you go into the case, it's got the name back up on that right-hand side screen. And yeah, next where it says copy, you can choose with or without hyperlink. AGLC4 doesn't like hyperlinks, which is a shame because hyperlinks are bloody useful if you ask me. But you can copy a properly formatted case reference. Sorry, that was just a little... It's sad, the things that make me happy, isn't it? That's definitely one of them.
Actually, the AGLC5, they're all doing hyperlinks. So we've been talking with the Melbourne Uni, the Australian Law Librarians group have been. So we're all figuring out how to put in hyperlinks because it's a thing.
And so it should. But 4's only been out for 18 months.
I know, but the 5 group's already been decided and the editors have been put into place. So
good.
got into their ear straight away. I think there was a question on here that said, what is the difference between H and the C of the citations? I would just say to you, don't stress about them. It's just showing you that they are considered fine. They're considered normal. No, there's nothing wrong with that case at all. That it's just nothing to really worry about. It's just a normal case. It's only the yellow and the red that you really want to be concerned about.
Yeah. So some litigation history, but nothing. Yeah, it's business as usual is what I would think of those.
BAU.
Yeah. Yeah. So you go in. So with whether it's the right case or not, you would be looking at the flags. You would be looking perhaps at litigation history. So has it been cited by anything else in a negative or other way? But the flags will help you get there. Another thing that could be worth looking at, and actually I can't remember if I put a note in here. Actually, in one way I think that AGLC 4 is quite useful is it actually lists out kind of the order you should think about, where have I put it? Medium mutual citation, sorry. I knew I put it in here somewhere. So rule 2.2.2, not very big, so I'm not sure that you will see it, but I think as a general, this is actually quite a good way of thinking about these cases too. When you've got 2 or 3 cases to choose from, and one of them is an authorised report, and another case is an unreported decision, a case that has been cited as an authorised report is something that the judges themselves and their associates have said, okay, this is something that is important enough that we think it needs to go into an authorised report. It's been double checked, it's got to that level, where unreported decisions are of less weight. So they're, you know, they are kind of the 2 of hearts to your Queen of Hearts, effectively. And so I think this list, which is basically saying, look, if you've got, really this list or this rule is around if you've got multiple versions of the same case, then, okay, if you've got an authorised report, then that's the one that you should be citing. But if you don't, then a generalist unauthorised report, that will trump a subject-specific or unauthorised report, and then an unreported judgment, etc. I mean, the reality is these days everything is reported. It's not like the olden. So those of you who've been into the Tom Smith Library, that's how I studied law to start off with. I mean, that was the big barrier to entry, which is why lawyers were rich. In order to even know what the law was, you had to have one of those leather-bound books and be able to find it inside. These days, we just have to pay large amounts of money to the publishers. But, you know, at the end of the day, access to the information is significantly easier now, which is why your job is harder than mine was when I started, because being able to ask the right question is way more important than being able to find the information. The information is easy to find. Making sense of it, there's where the skill lies.
Kath?
Yeah.
With the sort of hierarchy of the authorised reports and the unreported decisions and stuff,
yeah.
If you know that an authorised version exists, but like it's a paid version or something like that, and you can't find the actual judgment, but you can find the unreported one with the paragraphs, and you want to make a pinpoint reference, would you then cite the unreported one, or would you just cite the reported one but leave out the pinpoint?
What I would want you to do if you were working for me, and what I would appreciate as your lecturer, I'm not going to talk for everybody else here, because seriously, in an academic basis, the authorised one is higher. The main purpose of you sharing your reference with me, if I'm your boss, is so I can have a look at it. So I am actually much more interested in getting the reference that I can find and have a look at. If you were, for me, as the academic responsible for marking it, if you were to put the unauthorised reference into the footnote and make a note that with the authorised reference, and that you actually haven't had access to that so you can't pinpoint, I would be very happy with that, because that's showing academic integrity and it's demonstrating that you're actually respecting that, yeah, I do go and look at some of the cases that you cite, particularly ones I haven't heard of myself in advance. To be quite frank, that is, from a strategic point of view as a student, that's something that you should probably check with your academic, because we're a weird mob, to say the least. And, you know, the power, it goes to some people's heads. You know, the fact I'm not going to be doing this, I can say these things on recordings now. So, yeah, I mean, there's technically what is right. If you were writing a PhD, basically you would need to get access to that case and have a look at it. If you were taking it before the High Court, the firm would get access to the actual authorised report for you, and you would make sure that you could do it. But you know, if you can't get access to the authorised report, let's not pretend. Like, let's actually have some integrity around it, would be my call. And I don't know, Anna, what do you think the partners that you work for would be saying in relation to that? They're looking to read the cases if they need to, aren't they?
Oh, definitely. And if it's available in its authorised version and you can get that readily through the firm, do it.
Yeah.
Get it straight away. But if you can't and you know it has been authorised, it is so important to make sure that you do show that, yes, I've got the unreported here, but here's the citation to the authorised. Should we need it, we can get it elsewhere. It's quite important just to start getting to the habit of doing that.
And I haven't extracted it here. I'm a big fan, by the way, of having a GLC 4 open, the PDF version open, and using Control F or Apple F to find things as you go. But it might be the rule before, basically shows you that if you are using the unauthorised citation, to cite it with the authorised citation first, but then add on the lower citation with the pinpoint subsequently so it can be found. And it's, you know, and that's showing me integrity.
Definitely.
Which actually brings us really neatly, because they are related ideas, to this question of, can you use unreported judgments? So the partners in your firm, are they, if you can't find something that's reported or authorised, are they interested in the unreported judgments?
Yes.
Yeah.
Very much. If you can't find it, you give them the next best thing.
Yeah.
If it's a case note at the end of the day, that's all you've got. That's all you've got. A lot of the time you'll find the very historical old cases are not available in its full entirety, and there's only case notes that you can find in journal articles and other footers and headers. So just keep note that where you've looked, where you've got the information from, and just apply what you've got, what you can find.
Yeah. And look, and sometimes even when you have an authorised decision, if you've got an unauthorised or an unreported decision that for whatever reason is really different or new or deals with something. So I often work in areas relating to technology, and basically nobody in technology wants to go to court, right? If you have to have a fight at all, you want to arbitrate it, you want to keep your dirty washing out of the public. So particularly when it comes to really new technology, stuff to do with AI or stuff to do with blockchain or whatever, often, and me, remember, not a litigator, but one of the things that informs me as a transaction lawyer is what's gone wrong. So even though it might be unreported, the fact that two parties entered into agreement about something, and they ended up having a fight about it, even if it's not going to be reported because the law is not particularly interesting, the subject matter is interesting to me in a different way. So again, sometimes it's not what do I need to present to have the strongest background to the legal case. It's actually, what does my client need? What is the partner I'm reporting to actually trying to achieve here? And really thinking back to, well, what is it that I'm looking for? So in particular, you know, I do come at this as a transactional lawyer. I want to know what people have had fights about so I can preempt that in the contract that I write. Case summaries. So again, we're sort of moving to the same thing. I think you've just really answered that question a second ago. I want to remind people that case summaries and case notes that are on law firm websites, they're not there to help you understand the law better. They're there to help the law firm sell their services. So think about that when you read them. And if a case is available, personally, I love a good summary. I'm very lazy. I would much rather read the textbook or a summary, work out what it is, and then I know what I'm looking for when I'm reading the cases. Other people are different from me. The way their brains work is different from me. They like to come to it, read it afresh, and have their own point of view that isn't tinged by those other things. I'm got a big enough ego that I can have my own opinion without being too worried about that. But again, think about why you're reading it. I mean, my guess is that you're often finding people in your firm that are tasked with, can you spend a bit of time going and seeing what other firms are saying about X, Y, and Z, or a you know, a case that one of your litigation team is involved in, you know, decisions made, and you're racing to see what other people are saying about it first so you can get a different angle on it. I mean, we research for a whole lot of different reasons.
Definitely.
Is that right?
Yeah, well, it's funny to say that everyone reads the law, what the lawyers are publishing, is at the end of the day, they're just putting a spin on what was from the textbook or what was said by the judge, and they're just putting their own little 2 cents worth on it and just going,
Yeah.
We're shining it up. This is a new shoe.
Yeah.
It's a shoe we've just pulled out of the closet and it looks brand new.
Absolutely. And now, you know, if, dare I mention him again, you know, old Gino Del Pont does that, we might all sit back and listen to it in a way that might be quite different if Kath Nolan does it. You know, if Bob Austin decides that he's going to, you know, make some statements about, you know, the way the Corporations Act works, we're all going to listen to that differently from how we might listen to it if, you know, a commercial partner in a big firm says it. Because, again, secondary sources have different weight as well. And so that's, sometimes it's important to actually pay attention to who the author is and see what kind of credibility and status they have. And in the law, it's not, you know, actually, and I say this with love and respect for my colleagues who have them, but a PhD doesn't matter. Being a judge matters. Being a regulator matters. So, you know, if we're looking at competition stuff, we care about what Graham Samuel says or what Alan Fels says. But we care about what Alan Fels says not because he's a Professor Alan Fels, but because he ran the ACCC for 10 years. So think about it in that way. Sorry, there's a question we missed. But go on, Steph, sorry.
Just giving you a heads up that it's now 10 to 7. So
okay.
We might need to start wrapping up.
Okay. I do want to answer Steph's question quickly, that cited with approval means that in the case, the judge referred to, so we were looking at Musumeci as a list. So in one of the cases where Musumeci was cited with approval, that means that one of the ways that the judges in that case came to the conclusion that they did was using Musumeci with approval, the foundation of that. So the last thing I thought we possibly might want to talk about is what you do with all this research output. We can talk about that anytime though. I'm just wondering, particularly while we've got Anna, and I'm not sure if Jess is still with us here, if we've got any particular questions you guys would like to ask them about research in particular, but also about just moving from being a law student into being a graduate. Graduates spend a lot of time with Anna. So a question from Marius here. How do you find the binding precedent in a case? For example, for instance, how do you find the core message of a case that you have not studied or found in a book? Does it make sense? Yes, it does make sense. And the answer, I think, is very carefully. That's an unhelpful answer though, isn't it?
Normally you'll find in your catchwords from your case that there's a couple of hints. The catchwords and the main little digest, that's your hint. I guess if you think back to high school, you think you get an essay question, that's the start of the case. You've got
Absolutely.
your couple of main tags. Think of them as hashtags or, you know, your little @ tags. And
so in some areas they're less helpful than others as things have evolved, because we've got basically, it's probably about 100 years ago that they set the catchwords. There's sort of like this index for how we're going to index cases. And so every case, as it's decided, as they decide to authorise it, the judges and the associates will say, okay, this is a case, it falls under the main heading contract, sub-heading damages, blah, blah, blah. And so those things will help us. And so as you're reading the case, you think, okay, this is what they've decided that it is. Another good way is, again, going through that citation process that, so either in Jade or in the Westlaw thing that we were looking at, if you see that a case is cited often and you can work out which bit, because they've pinpointed, so paragraph 4 has been cited 7 million times, then paragraph 4 probably has the most important bit in it. And so that can be a shorthand. I don't know if you've seen this. I don't know if you've come across this, Anna. This is, it's a couple of years old now. Federation put out this book. And I think their plan initially was to do one every year and keep updating it, but I haven't seen another one. What it is it's the 200 Australian cases that have been cited the most often. So it's kind of like, and they're literally in order, which I think is hilarious because I don't think I've ever read number 1, which is House and the King, a 1936 case. And of course it's an appeal case. So a number of them relate to particularly civil procedure, etc., because they get cited a lot, right? So it also has a nice little index at the back which goes by the Priestley 11 subjects and has the top 20 most often cited cases in each of the Priestley 11 areas. And it's got like a nice little case summary. But again, the cases that are most value, you will often have lots of secondary sources and commentary around them as well. And so, you know, unfortunately, Anna and I are agreeing here. I think it works better to start with the secondary materials, get a reasonable sense of what the academics and the judges think the key points are, and then dive into the case that's going to demonstrate and prove that, rather than start with the cases and trying to glean what's the principle out of nowhere. So I would narrow it in slightly differently.
Definitely. And the only reason why Cathryn and I agree on that is because it's such a time saver. And you will notice that as soon as you do a clerkship or a graduateship somewhere, that all of a sudden an hour feels like 5 minutes. Yeah. And it's just gone. So any tips, anything that we've said to you tonight, especially about the secondary materials, I cannot stress enough, they are your best friends. Yep. So get used to them.
And one of the reasons actually I'm so excited about the initiative that the LSS is now, I know Marius has been involved with getting some peer support and some peer, study group stuff happening together, is because actually one of the first things you would do in a firm is you would talk to other people. You'd say, okay, you know, I need to do something about blah, blah, blah. Any ideas? Any, you know, what have you seen? What do you think? How would you approach it? Because getting it wrong, you know, it's, well, in a firm, you're not in competition with each other, I guess. And you're actually, that is a really good way to get that diversity of thought in, and then you narrow it down. So start with secondary sources, which I would suggest should include your mates.
Oh yeah, and especially the person who's asked the question, your buddy, have a chat to them and ask them. Yeah. You'll find that there's one person in that group that you're sitting with who is a guru at this topic, and it's their passion. So if you ask them that question, they're going to just give you so much to go off. So better to, I always say to people, ask your librarian first, ask the person you've asked questions, say, ask them, challenge them in a way. Where would you go? Where do you recommend I start? And that's,
absolutely, and they'll appreciate that.
Doors open. Oh, they love it. They love to know that you want to know where to go, where they would suggest. Sometimes they'll be smug and go to the librarian. Or they'll just say,
or you means they don't know.
Ask later. Yeah. Or ask me in an hour. I'm busy. Don't think of it as a real brush off. It's just them, as Cathryn said, not sure themselves.
Well, and it is the big difference between law school and the real world. Again, in law school, I ask you a question, I'm pretty sure I already know the answer. When you work for me, I do not waste my money asking you questions I already know the answer to. I ask you questions I don't know the answer to. So I'm happy to have a conversation about where to look. And it's, you know, it's a slightly different dynamic. Have we got any more questions? Because I'm seeing the time. We've got 2 minutes. I'm freaking Steph out.
No, it's okay. I just want to take this opportunity, just since it's been raised, the LSS does now have a private group on Facebook for peer support study groups. So that's something that Marius sort of beat us to. He came up with this great idea just as we were developing it. So it's there if you need it.
Perfect.
My last thing that I want to say is that I'd love to get a picture of everybody for the LSS. Is anyone, if you're not willing to be in this screenshot, you can just keep your
oh, come on, put your
camera off. Otherwise, strike a pose, and I'll just do a quick little screenshot. Okay, ready? 1, 2, 3. Thank you. I'll hand back to Kath or any other questions.
Yes, please ask as many questions as you can.
Western Australia. Sorry, I get excited when I see students who come from all over the place. So it's exciting. So look, I think we probably need to finish up. Anna, this has been, I've loved having this chat with you.
It's been an absolute pleasure, and I please anyone that's interested in finding out more or picking my brain or anything, just please reach out. I'm happy to answer any questions more generally, I guess. And if you do want to apply for a seasonal clerkship, they open up in July in Maddocks. So do let me know if you're coming, and then I'll get to meet you face to face, and you can go through my long 1 hour long training session. But Cathryn, this has been amazing. Thank you, Steph, as well, for having me.
Thank you so much, Anna.
It's my passion, research, legal research. So yeah.
And well, it matched with my passion that we, take people out of law school and make them into good practitioners and get them to and I can tell from just talking to you, like me, have a job you love, and that, working in law firms, it's not for the faint-hearted from time to time, but you get to work with great, enthusiastic, clever people solving interesting problems that make the world go round. And I know, interesting is different things to different people, but in a good full-service firm like Maddocks, there's such an opportunity to be exposed to lots of different types of commercial activities. So so I would encourage all of you who are at the right stage in your degree to do your best to get that experience if you can. And we just
and if you need more info, it's all on the Maddocks LinkedIn page. They have this, I reckon they've done a great job this year actually on their clerkship program module. So every year they develop something new, and this year's been phenomenal. So
awesome.
Do have a look.
I'll have to have a look.
Yeah. I hope to meet you all one day.
Well, hopefully we'll all be back on campus eventually.
True.
Steph, as always, thank you. You're the bomb. Thank you to all of you who gave up so much of your evening. And this will be recorded. I will edit out any of my swear words, add some in, who knows. And I will share that with you, Steph, later. But thank you all. You know where to come to me for questions too. Thanks, guys.